thanks for joining us. And Barry, like we talked about, this is recorded. So if anybody watches in the future, thanks for watching this with us. Ashley, you are going to get some one-on-one time with Barry, it looks like. Like I said, we are recording it, so Barry's, still go through everything like you normally would. But Ashley, anytime, as long as Barry's okay with it, anytime you get a question, keep your mic unmuted or unmute yourself, feel free. If you want to turn your camera on, you can, and make it a little bit more like we're in person if you want to. But so Veteran Business Outreach Center, I'm not sure if you know much about us, Ashley, but we help veterans start and grow small businesses. We work through the SBA. We're a program through them. And part of what we do is finding outside resources, community partnerships to help our clients, to help veterans start and grow these small businesses. And a good example of that, we always talk about a bail team, your banker, your accountant, your lawyer, and your insurance. Just not in that order because Troy can't spell today. But Barry is one of the lawyers that we have been working with. And, we can't make recommendations. We can't say, hey, you have to go to this bank. Hey, you have to go to this lawyer. But we can say, hey, Barry's worked well with us in the past. He's worked well with our clients. We recommend if you would like to, you go ahead and talk to them. So, Barry, thank you for being one of these resources for us. We really appreciate it. You're a big help to our clients doing these classes. Speaking one-on-one with their clients and taking on clients of your own through us. So really appreciate that. And without any further ado, why don't you go ahead and take it away, Barry?
Sure. Okay, let me start by saying thanks for saying that about us. And then I do the same thing. I probably get, I wouldn't say a phone call a week, but it's like probably once every 3 or 4 weeks where somebody calls me and asks me about setting up a new entity and getting involved. And I usually ask the question, are you a veteran or a family member of a veteran? Because if you are, there's really no better source for information than VBOG. And I say that because obviously they've been doing it forever and know what they're doing. And that they have a wide variety of services they offer. And they're a heck of a lot cheaper than going to me or other third-party vendors. So I want to talk a little bit about me just for a minute. I hate doing it, but so these are some of the things awards I've been given by different entities. But I want to go and talk a little about what I do. So there's basically 2 types of things I do, and they both relate to business. So the one thing I do is pure what we call business law or corporate law. And that means I get involved in representing businesses in the formation side, as they restructure. I have a couple now where we're bringing on some new members. So that does some restructuring where they're buying people out. Maybe it's a father, the son's coming in, he's trying to buy out his dad, or we're going to buy other businesses, or we're going to sell other businesses. I also get involved in, as you just mentioned, Ashley, contract review, leases, and then just general business type stuff. As you get bigger and you have employees, there's also just employee issues. And then oftentimes the client's going to call and say, what do I do about this employee? Or what do I do about this particular situation? And how should I handle this type of thing? So that's kind of half of what I do. And the other half of what I do is what we call civil litigation. And civil litigation for us is, meaning me and the other guys here that do that type of thing, is business to business typically, or business to individual. But it's litigation that involves going to court and fighting about things. Oftentimes it's a contract issue. Yesterday was, they got into a dispute. I can't remember what the dispute was about with an employee. And so then the employee's mother's boyfriend started posting negative reviews on various social media. And so they came to me to say, hey, what do we do about that? Can we bring some lawsuit to stop that? And then other times we'll be involved with contract disputes where we hired someone to do a website for you and maybe that they didn't do a good job, or you did some services for somebody, they didn't pay you, and then you hire a lawyer to get involved in dealing with that. But let's go through the topics that we're going to talk today, and it's really all the nuts and bolts of setting up your own business. And Ashley, you're a little bit ahead of the curve on some of this stuff, but I'm going to start and I'm going to walk away all the way through these topics. What are the 3 things every business needs? Then what are the various roles that we have in a business? What are the different business entity choices? And you mentioned sole proprietor is one. There's a joint venture is another one. there's partnerships, there's corporations, the one you've chosen, which is limited liability company. And I may try to talk you out of that.
Yes.
So then we're going to talk about DBAs. Then we'll talk about the corporate shield, buyouts and how that gets handled. What happens if the business goes down? And that's one of the things we talk about. And what happens when you sell the business? And then we'll deal with the final issues, which are intellectual property and company name things. So I'm going to jump right into, in my world, every business needs three things. They need capital, they need a product or a service, and they just need a decision maker. And again, every single business I have deals with these three things, maybe different ways, but they have to have those three. And so the example I would give you is that if Troy and I were going to set up a hot dog stand, we would need capital. That is, we need some sort of money, whether it would be, I actually have cash, I have some credit, I can go to a bank and borrow some money, I have credit cards to raise some money, or I get a bank loan, or I'm going to borrow some equipment. But I need something to get started. You generally can't start with nothing. Second, I need a product or a service. Again, if we're going to do a hot dog stand, I need to get the hot dogs and buns and have somebody have to cook the hot dogs and sell the hot dogs. And that's the service part of it. And the third, and this again is every business owner needs this, is a decision maker. Someone's got to decide, where am I going to put the cart? Are there days I'm not going to operate the cart? And what are the hours? And so right now, Ashley, if you're the sole person, you're going to be involved in doing all those three things. And have you raised capital already?
I'm funding my business myself.
So you're the capital person.
I'm
And
the
then,
person.
and then are you going to offer a product, or are you going to offer a service, or is it a combination?
It's both.
Okay, and so what's the product/service, if you're willing to talk about it?
Certainly. And this is a sign business, but it's all traditional hand painted signs. So think about the business before there was vinyl
Right.
on the market and car wraps. The product is a handmade sign, typically out of wood or an aluminum, or the service would be coming to your location and painting directly on your surface or storefront.
Cool. Okay. And so since you're the person, you're right now the operator, right?
Yes.
You're the one making the signs, and then you're the decision maker.
Yes.
You're deciding where you're going to run the business and how you're going to do it. So again, we then, in addition to looking at those ways of looking at it, we look at it this way. What does the owner do? And typically the owner is the person that funds the business through cash or credit. And the names that we use for the owner vary on what type of entity it is. If you set up a corporation, we call you a shareholder. If you set up an LLC, we'd call you a member. And if you set up a partnership, we'd call you a partner. The decision maker, and again, this is going to be as you grow, and that's the person that makes the decisions on how the business is run. In a classic business, the owner doesn't really make the business decision about how to run the business. They give like the overall direction, and they have an officer or a director that actually says, here are the goals, how to achieve these goals. And again, in a corporation, it's an officer or a director. In an LLC, it's traditionally a manager. And then the operator, that's the person who actually is going to make the business run. And typically we call those either independent employee contractors or employees. And they're the ones that actually do the nuts and bolts of running the business. So I wanted to give you an example, and we lawyers like to use history. And the main reason you're setting up a business entity typically is so that you're not liable for the contract debts of the company. And so the example I give you here, and you're from Chesapeake, you should know this one. So in 1553, a corporation formed in England for the discovery of lands unknown. And what they wanted to do was raise money to have a ship built. They're going to obviously have to pay a captain and a crew, and they're going to sail that vessel to the new land, of course, America. They're going to have to fund the salaries of the people to oversee the venture, because again, the owners are just putting up money. Then they're going to fund the cost to return the vessel and then sell off all the great things they got and split the profits. So that was 1553. They did it. It wasn't until 1585 that they got all that stuff done, and they got their first set of colonists that went to Roanoke Island. And when they went back in 1590 to get back the goods to come back, all they found was CRO carved on the trunk of a tree. And if you may remember, it's called The Lost Colony. There's that play that they do on Roanoke Island. And so, as I point out, as of 1553, what do they know about America? Virtually nothing. what were the potential liabilities? Completely unlimited. They had no idea what it would have been. And if they had gone around to people in England and said, hey, look, will you agree to cover 10% of the liabilities in return of 10% of the profits? I doubt they'd ever find anybody that'd say yes. So what instead they did was they said, let's set up a budget. From that budget, we'll sell shares and we'll use that money to cover the costs. If we run out of money, we have to issue more shares or we go out of business. And so the way it worked was if they came to me, I would say, here's $1,000 and I get whatever that percentage of the profits is. In this particular case, as we know, the colony was abandoned, so it was a total loss. I don't know what the dollars were, but remember, they didn't make a single penny on the thing. But the good news to me, if I was an investor, was the only thing I lost was my investment. So I put up $1,000, I lost $1,000. If I didn't do that, in other words, if we'd set it up as a partnership or as a sole proprietorship and I just did the whole thing, all the additional costs I would have to keep funneling in and funneling in and funneling in until I eventually went bankrupt. So that's why, generally speaking, we start suggesting, let's go ahead and try to set up some sort of business entity. Now, as you talked about, when you first set up, you were the classic, what we call sole proprietor. There's some advantages. No formal registration, and you'd have to do that other than maybe getting a business license. No separate tax return. Now, you would have had to pay sales tax if you sold these things or service tax, depending on how you split it up. And there's a business and professional occupational license and use tax. But basically speaking, there's no documentation of the business arrangements and there's no documents filed with the SEC. So it's the easiest one of the entities to form. The downsides, as you understand, is you're personally liable for every debt of the company. So in your case, if you went to a paint vendor and bought paint and they gave it to you on credit and then you couldn't sell the signs, then you still owe the money personally. Same thing's true for the wood that you're buying. If you went to Yukon Lumber or one of the other local lumber people and they sold it to you on credit, they'd come back and get a judgment against you if you didn't pay it. So we generally try to say, stay away from sole proprietors unless there's a particular reason. Now, there are some businesses in which it does make some sense, where you really have a pretty good idea about your liabilities. And I would say in your case, a sole proprietorship may not be a bad idea. I, again, generally wouldn't advise it, but I don't see any big risks for your business. Are you not hanging the signs? Are you doing that?
Typically, no, I do not do installation.
So if you were hanging signs and doing installation, then I'd be a little more concerned about, a car hitting somebody or a sign falling, hitting somebody in the head. But that's one of the first things that we do as a lawyer, start looking at what are the potential liabilities. So this is the next thing that comes up, and it's called a joint venture. And it's basically any agreement, doesn't have to be in writing, where two or more people want to do a business. So in this case, Troy and I decide we're going to buy a house, we're going to fix it and sell it and split the profits. And I put a little star there because we have to talk about what profits are. And this is something you need to start thinking about at some point, because you can only get so big having one person in your business. It's just a general rule, there's just a limit. So one of the advantages of a joint venture is, while it's helpful to have one, you don't actually need a written agreement. There's no filing with the state corporation commission. The only thing you really need is a business license. So cons, you're still personally liable for any debt of the venture. So again, if Troy and I buy the house and we try to fix it up and things go horribly wrong, he and I are personally liable for all the debts. Secondly, and this is a big thing for us as lawyers, we'd like to get everything in writing. And the reason we do, because if it's not in writing, we get into a dispute. So let's say Troy and I decided we're going to go in this business and we're going to split the proceeds 60-40. Well, I thought I was supposed to get 60. He thought he was supposed to get 60. If we had it in writing, we avoid that problem. The second thing is, and again, this is where we like things getting in writing, and one of the reasons people dislike lawyers. And I just sent an email to a client the other day. He's bringing his son into his business. And I said, here's a list of questions I have. And the client was like, you're killing me with all these questions. Well, those details are what we like getting resolved in the front side, because if you don't, you run into problems in the back end. And so the example I give here is, Troy and I say we're going to split the profits. Well, if I go out and buy a sink, do I get the cost of the sink back, or do I get the cost of my labor? If Troy finds the buyer, should he get some reimbursement for that effort? So you really kind of get caught up in exactly what does it mean when split the profits. And that's a common thing. Clients come to me and say, we're going to split the profits. And I say, well, what does that mean? What are you counting as a cost? Are you going to count my time to go out and buy the stuff? Or is that just the material cost? And then what are we going to do if we need more money? And that's, again, another thing anytime you look at a business venture is, what if I need to raise more money? What are we going to do? And if it's a joint venture, we agreed that I'm putting up 60%, or is Troy going to put up 60%? So then a partnership is a little bit different from a joint venture in that a partnership, and this is the classic difference, is for a business generally. The joint venture is generally a specific transaction. A partnership is a general business. So, for example, Don and I decide to open a barbecue restaurant. The advantage, again, I don't need a written agreement. And again, I don't need a registration of corporate documents with the SEC. I do need to file what's called a partnership certificate, and that just tells the corporation who the name of the partners are. The cons, again, with the partnership, and why we generally don't recommend this, is if he makes a bad batch of barbecue, which he wouldn't, but if he did, and people get sick, they'll sue Don and I. In other words, they'll sue the partnership, and Don and I, even if I had nothing to do with it, are liable. The same if he buys some expensive smoker, we buy it on credit, and we don't pay for it, the seller sues the partnership and can recover against me personally. On the tax side, and again, I'm not an accountant or a CPA, generally speaking, the partnership files a tax return, but it doesn't pay its taxes. The taxes get flowed down to the owners, and they're the ones that pay. And so that's something at some point, Ashley, you're going to definitely want to talk to an accountant or a CPA, but I'll give you my take on the things that you get to.
Yes.
So corporation, that's one of the things we've talked about. And you're thinking about, or you didn't do it, but you went to an LLC because that's what everybody does now. So again, that's the original entity back in the 1500s that provided this limitation of liability. And again, going back to the barbecue business, Don says he wants to start a barbecue business. And if I give him $50,000, he'll give me 50% of the proceeds. He starts the business. He rents a fancy place. He completely renovates the whole thing. We run into another COVID pandemic and the business closes. The good news for me is I'm only out to 50 because that's all I put up. You know, if the barbecue vendors come and start suing the company, they'll get a judgment against the company, but they can't get back to me. I'm insulated from that. Cons, in this, you definitely have to file what's called an Articles of Incorporation with the State Corporation Commission. And Ashley, I think you did the same for I know you did the same for your LLC. What's a little different though, was with a corporation, you must list the directors and officers, and that's public information. Right now for LLCs, that's not public. In a couple of years, you're going to have to start reporting it to the IRS for other reasons and to the government. But right now, there's no public record of that. And make sure I'm clear about this, for a corporation, you don't publicly disclose the owners. So that's confidential, but you do have to publicly disclose the officers and directors. And then every year you have to pay a filing fee. We suggest you have written bylaws and documents relating to ownership. Not technically required, but it's kind of critical to maintain that shield. And then you must maintain separate accounts as a bank account and other corporate records, because you're setting yourself up as a separate entity, and you can be a single member of a corporation. And this is the way a corporation's laid out. And we always do it this way as a triangle. And so, Ashley, what do you think the responsibilities of an officer would be?
The overall sweeping goals of the company, but not the day-to-day.
Close, but it's actually, that's the officers do the day-to-day.
Oh.
Yes, the directors are the ones that do the sweeping overall ideas. And so what happens are, we start at the bottom, the shareholders, they're the people that put all the money in, right? And what they do is they elect the directors. And the directors, and you've heard this said sometimes about, you know, that the Apple CEO was on the board of directors of Google and all these other companies. The directors are the ones that say, here's the overall goal for our company. And they're the ones that select the officers. And the officers are the ones that go ahead and make the decisions about who's going to be an employee, et cetera. And so here, the directors are selected by the shareholders. And every once in a while, if you buy any stock, you'll get a little notice that's saying, hey, we're having a shareholder meeting. Please let us know which directors you're going to vote for. So generally speaking, the owners might meet once a year. The directors might meet once a month. The officers are going to be meeting every couple of days saying what we're going to do. And a CEO is a real common phrase, and that's the chief executive officer, typically the president. And again, who can remove the president? Generally the directors. And the reason I like corporations for people like you is that everybody, if you walk into an office and say, I'm the president of this company, everyone will understand what that means. If you walked in and said, I'm a member of my LLC, I can guarantee you most people are not going to understand it. Bankers won't, accountants will, but outside of accountants and lawyers, most general people won't even understand what that means. So that's kind of one of the first reasons I like corporations. They're very straightforward. So, and you haven't done this yet, but you will at some point, I hope, have to deal with ownership interests. And again, whether it's an LLC or a corporation, anytime you have more than one owner, you have to divide up that corporation or that LLC ownership interest. And so the example I give here is Don and I and Troy are going to set up a company to flip a house. Don owns the house. Troy's going to do the labor. He's going to get his hands dirty. I don't. And so what we do is we're going to deal with, and this is the critical distinction between an LLC and a corporation, is that profits and losses, voting, and proceeds upon sale are all linked together with certain exceptions. But generally speaking, those three things go what we call hand in hand. So in this case, assuming Troy's going to do $20,000 of work, but we're not going to pay him because Troy's a little like that way. He doesn't realize that we're not going to pay him, but he's going to do that work. He's going to fix up the house. I'm going to put up $25,000 for materials. Don's house is worth $55,000, and the total contributions are $100,000. And so in this, it's a pretty easy way to say Troy's going to get 20 shares. I get 25 shares. And Don gets 55 shares. We've valued everybody's contributions, and here's what they are. As I said, the voting's profits and losses go together. So in this case, say Troy and I want to paint the house orange, and Don wants to keep it white. What color will the house be, Ashley?
White.
White, 100%. Because every time we have a regular vote, Don's going to win. After finishing the house, we decide to rent it for a couple of years. If we generate $10,000 in profits, how much does Troy get? He's going to get 20%. I'm going to get 25. Don's getting 55. Now, an important thing, and this is going to come up to you in an LLC as well as in a corporation, is, and that actually is it's a trick question if I asked you this. How much would, if we generated $10,000 in profits, how much would Troy get? And the answer is, it depends on what Don wants to do. Because the company, again, is a separate entity. The company made $10,000. Don could say, I'm going to keep all $10,000 in the company because he's got 55% of the vote. If he does that, I get nothing and Troy gets nothing, except that if we're an S, which we would likely be an S election, we would have a tax form that said we're responsible for paying taxes on our percentage of the profits, even though we didn't get anything paid. So that's the critical difference, distribution versus taxes. For you, if they're the only one, that's not going to be a critical thing, although it could be, but that's something you have to at least consider. And then the third part I want to look at is, let's say we've got this business up and running and we've done a ton of houses and somebody says, hey, I want to buy our company for $100,000. How much is Troy going to get? He's going to get 20%. So again, the voting, the profits and losses, and when we sell the business are all going to go locked hand in hand. Now, lawyers can, and I do, play with things. And that's one of the things they hire us to do, is to make something look like one thing, but act like something else. And I can do that. So we could set up, say, I could say to Don, let's enter into a voting agreement that even though you have 55%, you agree to vote 6% of your shares the same way I vote my shares. And then I could do the same thing with Troy, and I could end up having, even though I don't own 51% of the company, I'd be able to control 51% of the votes. And that's a voting agreement or a voting trust. We can also do some other things with loans and changing things about profits, but that's the general way these things go. Voting, profits, and losses, they all go together. Again, anytime you're setting up an entity, whether it's an LLC or a corporation, if you have more than one person or even a partnership, you have to value the contributions by each. And when I say you have to, you're supposed to. And a lot of times they don't. And so the contributions, I've listed them here. For you, it's going to be cash. For you, it's going to be sweat equity, materials, tools, probably not real estate. Maybe it's connections in the industry. Maybe it's the credit standing to get a loan from the bank. So for example, we may go to the bank and Troy, Don, and I may all go guarantee the loan, but the bank may be looking at Troy's financial statement and saying, Troy's got a ton of money in the bank. We don't care about Barry and Don. They've got debt out the yin yang. So we're actually going to base our credit decision on Don. Well, in which case, Don's going to say, I want to get some credit for that. And then Tanya, I see you joined in. Anytime you want to jump in and say something, go ahead and do so or ask a question. So we're going through now the how many shares should each get. So as I said, sometimes there's a frank discussion of values. Most often what I see is people don't even think about it. They just go, hey, there's two of us, let's split it 50-50. 50-50 is my favorite choice to take for any business venture when you like paying lawyers and spending years in court. Because if it's 50-50, if you guys disagree about anything, you have to go to court and fight about it. Because there's no way you can resolve the deadlock, and eventually it'll destroy the business. My favorite example of this was a husband and wife set up a restaurant. They made it 50-50, and then they separated. And so then the husband would go through and fire half the staff, and the wife would go back the next day and hire them back. And then he would go back the next day and fire them, and she would go back and hire them back. And then each of them was taking all the money out of the cash register each night because they were each 50-50 owners. And eventually the business went out of business. Had they set it up 51-49, the business would have continued. Now they would have fought about what the voting is about. They would have fought about money, but the business itself would have continued. So my suggestion is, and Ashley or Tanya, if you ever bring somebody in, try to stay away from a 50-50. You want to be a 49-51. Obviously, the person 51's in great place. Another thing I recommend a lot, and I've gotten a ton of clients to agree to do this, is if you really are a 50-50, make it 49.5, and find somebody you guys both really trust to basically be the person that makes the decision in the event of a tie. And we've had some great luck in setting that up where we don't actually pay them, and we can craft certain things to make that happen, where they don't get taxed on anything or any of those types of things, especially an LLC, a great way to do it. And that solves this whole problem. The only issue is making sure the two of you find somebody you can agree. I did that for a client. The client and another person had been co-tenants of a lease for about 30 years and got along great, and then wanted to buy a building. They wanted to split it 50-50. I said no. The other person's lawyer said no. They eventually agreed with me that we were going to take this third party. And within about a year, they got into a fight about what day they should pay the rent, what they pay the mortgage. That my client wanted to pay it the day it was due. And the other person said, let's wait till the day, before the late fee kicks in. They couldn't get past that. We eventually had a meeting. The third party cast a decision, and it got that result. One of the things in drawing these up is if you're going to do a 51-49, and let's say Tanya or Ashley, you end up being the 49, or let's say the other person's the 49, you can require a specific number of votes for other things to give the 49 person some rights. Fairly common. So let's say, for example, Ashley, you're going to hire me because I'm good at woodworking, and I agree I'm going to get 50% of the business, but you don't want to give me 50, so you're going to give me 49. Well, I would say, okay, fine, I'll take 49, but for any increase in compensation that gets paid to you, we have to get approval by 52%. And that means that keeps you from giving yourself more money. Same thing for borrowing funds, hiring, firing, those types of things. So those are things that if you start getting through bringing more people on, which again, I think at some point you're going to have to, you can change the default rules so you're just not a simple majority. Can I have a corporation with one owner? You certainly can. And I know, Ashley, you did. With the owner owns 100% of the shares. Typically, they're the sole director, typically the sole officer. But, and I have a client that does this, you can have officers and directors that are not owners. You still get the protection of the corporate shield. And that's something that can be very valuable in some cases, that you get, say you're starting out a business, and actually this probably worked great through VBOC. You may talk to Troy or Don and they say, well, you might talk to so-and-so because they set up a similar business in California. You may want to have that person as a director on your company to give you advice. That way you can pay them as a director. They don't have any ownership interest. They can't vote themselves in as a director because you own all the shares, but you can get their input. And again, it's very common in publicly traded companies that you get other company owners to become directors. Kind of rare that you have to be a secretary or treasurer or an officer, but fairly common you get that. You still get that same corporate shield protection. Any questions? So let's turn to limited liability. And again, I apologize to Tanya and Sharita, but Ashley and I started earlier on about some of these things. She has formed a limited liability company. Did you do a operating agreement of any kind?
No, I did not.
Okay. Not required in writing. Basically, a limited liability company is, we call it a hybrid. It's got some of the features of a partnership and some of the features of a corporation. The owners in a partnership are called partners. The owners in a corporation are called shareholders. The owners in a limited liability company are members. And that's, again, one of the main things I hate about LLCs is that if you go to somebody and say, like, say you go to a client, you're trying to say, look, I want to do so-and-so, and they say, are you an owner of the company? Well, actually, you're a member of the company. You own a membership interest. So you're kind of an owner, but you're really a membership interest. In LLCs, you have two options when you form them. You can either be what's called member run or manager run, but there's no officers or directors. And if you're manager run, what that means is the members elect managers and the managers run the business. If you're member run, it's just the members run the business. There are no bylaws, but generally speaking, there's an operating agreement that spells out the relationship. You can have an oral agreement, meaning there's nothing in writing, but we generally suggest if you have more than one person that you have something in writing to tell us who's doing what. So an operating agreement which shows who owns what interest. And this again is the critical difference. And this is why actually I wouldn't have recommended an LLC for you, although it may have worked, is that you can allocate the voting, the profits, and the proceeds separately. So for example, in our house flip business, again, Troy, Don, and I are in there. We may think that Troy has the most to give us, like 55%, so he should get 55% of the profits. But we may think Don has a better idea about doing things, and so we may give him 51% of the vote. So we can move all those things around. And this is extremely common as you bring in employees. One of the things you need to do is somehow motivate your employees to make your business more successful. And one of the ways to do that is to give them an ownership interest. Generally, however, you don't want employees telling you how to run your business. So you may do a situation where you say, hey, employee, I'm going to give you 10% of the profits, but you get 0% of the vote. And then if we sell it, I'll give you 5% of the proceeds. Again, in the operating agreement, you can also spell out what a manager can or cannot do without approval of the members. And again, you can do that same thing about voting. It says, what are the actions that require unanimous consent? One of the topics I always like to cover, especially if you have more than one person, is what are you going to do in terms of capital calls? And so turning back to a corporation, if a corporation runs out of money, it's got two options. It can borrow money from somebody, or it can sell more interest. In a LLC, it actually can do what's called a capital call. And a capital call is where we go to all the members and say, hey, members, we need more money. Give us more money. And in the operating agreement, you spell out what happens if somebody doesn't give them more money. Do they lose their interest? Do their interests get revalued? Those types of things. So, and for any of you remember, there was a show called Orange County Choppers. I think that's what it was called. But and what they did was they made custom motorcycles. And they would spend all week making this custom motorcycle and sell it for a couple $100,000. But they also showed that actually their business model was they made regular bikes that they sold for $15,000 or $20,000. So to me, the LLC is like that custom bike. It's you have all this flexibility. But if all you're going to do is do a regular normal business, to me, a corporation makes sense. If I'm not splitting up the voting and the ownership interests differently, then it's so much easier to me to set up a straight corporation. Again, sometimes there is a need to have employees in the business that get a small share and no voting rights. This often comes up, especially with kids, that you may want to bring a young kid in and you don't want to have that type of thing dealt with. But as a corporation, so an LLC makes some sense. There is a real negative with an LLC to me with a default, and I should have said this. LLC have what's called default rules. And a default rule means if you don't choose otherwise, this is what's going to happen. One of the default rules with a corporation is if I own 20% of the business and I die, my 20% goes to whoever my heirs are. In a LLC, what happens is my heirs get the right to recover the money that I would get. That is to say, if there's a distribution each year, they'll get that distribution, but they have no voting rights. So let's again go back to where Troy, Don, and I set up that house flipping business, and Don had 55% of the vote because he threw his house in there. Well, if Don dies, his wife would get 55% of the profits, but the voting would be split between Troy and I would have the majority because I had 25 and Troy had 20. Don's 55 comes off the table. The same limited liability protection as a corporation, so you get that benefit. And then, Ashley, did you have a question about this part of it?
No, I'm good. I'm clear.
Okay, cool. And again, if anybody else has a question, just pop in. So let's turn quickly to what's the first thing you do in a business? The very first thing you do is going to choose a company name. It can't be the same as any other registered entity. So if you call the SEC and say, I want to register an entity and it's got a similar name, they're not going to accept it, but they do accept some slight variations. In looking at your name, consider what it says about what you do. And many of you remember, IHOP, International House of Pancakes, made a big deal a couple months about changing their name to IHOB, which is International House of Burgers. They wanted to give the input to people that they are offering burgers, and so that's what their name was. So often I see people name companies after themselves or their, something that doesn't really tell people what they're doing. And there can be a reason to do that, but think about it when you're choosing it. Do you want to have it to be your business name? There are times that you have a separate company name, but then do business under a different name. And the classic example, if you haven't seen it, I highly recommend it. It's a movie called Founder. And it's about a guy named Kroc who basically came up with this idea of franchising multiple hamburger restaurants or whatever throughout the United States. And the restaurant's name is McDonald's. And he makes it clear in this movie that he actually met the McDonald brothers. They had done a couple of restaurants and were doing okay. But he really was going to take it nationwide and make it very, very successful. And he could have done it without dealing with them at all. He could have called it Croc's. But he said to himself, at the time, his name had an Eastern European flavor to it. He was afraid that would take off a lot of potential customers. And he thought McDonald's was a great name. And that's what he wanted. So what they did was they used that name as a DBA for all their franchises. So if we went today and looked at a McDonald's right now that's being offered there, it's not really a McDonald's, it's something else, but it's registered as a DBA, that is a doing business as. It's a very simple process. You file a form with the State Corporation Commission, and you can have more than one. And I see this come up pretty regularly with clients that want to do one field of business, but that want to offer some other services as well. And again, Ashley was talking about doing a sign painting business. If she decided that in addition to doing signs, she wanted to do some totally different business, she could set up a separate DBA. It would be all through the same accounts and the same records as her company, but to the public, it would look like a separate company. So let's go over, if you're setting up a corporation or an LLC, the main thing you want to have is what we call the corporate shield. And I want to go over this to make sure you're very clear about this. Individuals are liable for any tort that they commit. And tort is a legal phrase, meaning you didn't act with the standard of care needed. So for example, if I'm driving on business and I drive drunk and go through a red light and hit somebody, I'm personally liable. Now the company's going to be liable as well, but I'm going to be personally liable. In contrast, if I'm an owner, and I am an owner of our company, and one of my employees goes out driving a company car and is drunk and hits somebody, the creditor can sue that individual, they can sue my company. If they sue my company and they completely wipe out my company, which they could, what if they hit a school bus? And we've had a couple of those. I still personally, they can't reach anything I own. So they can't reach my house. They can't reach my bank accounts. All they can reach is the company. So that's the classic tort debt. Ashley, again, looking at your business, I don't see tort debts. In other words, I don't see that there's a sign falling and hit somebody on the head. So you don't have to really worry about that. But in other businesses, you do have to sometimes, let's say you were a house inspector and you were going to go and do all the inspections yourself. Well, if you inspect the house and fail to notice that some gas appliance is giving out carbon monoxide and somebody dies, they can sue the business, but they could sue you as well. The second thing is contract debts, generally speaking, don't fall on me unless I sign a personal guarantee. Generally speaking, landlords and banks know this rule very well. So generally speaking, they're going to require a personal guarantee. Sometimes vendors will, oftentimes they won't. But that's something you just need to be careful. If you go to a vendor and say, I want to establish a line of credit, they're often going to have a credit application. It'll ask, where do you bank? How long have you been in business? Give us some financials. The important thing you're going to look for is, does it have a phrase in there that says personally guarantee? The other thing to consider, it's not on this slide, anytime you sign a contract, you should always sign the contract in the name of the company, by, and then your name. So you never want to sign Ashley. You would sign, for example, if it's Ashley Signs LLC by Ashley, that means Ashley's not liable on that. So let's say you committed to provide all these signs to a company, you signed this contract, they paid you a deposit, and then whatever happened, you couldn't fulfill it. The company could sue you if you'd signed the contract individually, saying they dealt with you individually. But if you'd signed Ashley Signs LLC by Ashley, they can't touch you. The final part of that is they can what's called pierce the corporate shield. And again, that's whether it's a corporation or LLC, if you don't follow certain formalities. And those include separate bank accounts. So that's generally the thing. If you have, and we've had this come up, if you want to fund your kids' college education, make a distribution to you from your LLC account to you individually, and then pay it out of your account. Don't pay it out of the company account. And there's, a little bit of leeway there. If you're paying your cell phone or you're paying your tablet that you're using for business and personal, nothing wrong with that. But you can't pay purely personal things out of there. You also need to maintain corporate formalities. And that's why it's important, we think, to have minutes that say the corporation was resolved to do this and agreed to do this. And then you have to operate the company for company business, not as some sort of personal concern. Buyouts owners. What are we going to do if, again, we have more than one member and Troy dies? What are we going to do about his interest in the business? If Don dies, do we have to deal with what Don's wife tells us to do? If Troy wants to move out of state, how are we going to handle that situation? And does it make a difference if it's an LLC or corporation? And again, the default rules are yes, they're dramatically different. So in a corporation, if someone dies or they become disabled or they move out of state or they stop working, they are still an owner. And I usually have, and I have now, I think 3 of those lawsuits going on where somebody has stopped working and the two people had formed the business and given themselves ownership interest because they were working for the business. Then somebody stopped working and the other person's now very upset. Well, unfortunately, the ownership is totally separate from the employment relationship. And even if they stop working, they're still an owner. And that can get to a big fight. Again, the default on the LLC is if the person dies, their heirs get the rights to the money, but not the rights to the vote. And so let's say, in this case, Don dies. Don's wife can't tell us what to do if it's an LLC. If it's a corporation, she could. If we sell the business, Don's wife's going to get 55% because that's his ownership interest in the LLC. Again, if it was a corporation, you get the same thing. And where the ones I've seen that get the maddest are an owner quits to work for a competitor. What happens to their ownership interest? Well, they still own their ownership interest unless you've drawn up some documents that say they can't. And that's when you're starting these in, as you bring people in, that's some of the things you need to think about doing is putting in restrictions on people, what they can and can't do. And if somebody stops working, that the company has a right to buy back that ownership interest. Typically, we try to put in some formulas. What if the business falters? And again, that's I'm turning back to 1553 when they decided to try to fund the exploration of the Roanoke Island that closed. They liquidated the assets. They pay off their liability and they close the doors. You don't file bankruptcy unless you're going to reorganize, because corporations just close the doors. And if you did it right, you're not personally liable for any shortfall. When you sell the business, and that's generally speaking what's going to happen at the end, either you're going to die owning the business or you're going to sell it, one of the two. And if you sell it, or you may give it to your kids or you may sell it to your employees, the buyers want to make sure they have the proper documentation of who the owners are. I've only had this happen a couple times in my career, and I've been doing this for like 35 years, but I've had times where we've had to go back and say, you know, I know that guy left 5 years ago, but he never signed over his shares. And again, that's an important distinguishing feature. In a corporation, you actually get typically a certificate that says, it's a piece of paper that says, I own 50 shares. When I leave, I have to sell that certificate over. It's like a promissory note, or it's like a check. Or like a certificate of title to a car. It's actually what we call an indicia of ownership, and you have to keep track of those. If they lose them, you can come up with paperwork to deal with that, but you have to have all that paperwork lined up. In an LLC, it's just a membership interest, so there's no separate paperwork, but we do want to have a bill of sale that says, hey, I'm selling back my interest, and an effective date. And again, your accountant's going to need to know that, because the tax reporting depends on who owned it at what time. If we sell the business, we pay all the debts of the company, and the remaining amounts are distributed to the owners in proportion to their ownership, unless we had some other side deal, which generally don't. I want to get close to closing by dealing with accountants and lawyers. You have a really great resource here with VBOC, and I encourage you to use that as all you can, but you probably will need an accountant as well. You may or may not need a lawyer, but an accountant you will certainly need. When you deal with accountants or lawyers, you need to do your own due diligence. I hate that phrase, but you do. You need to do some inspection and make sure you feel comfortable with that person, and recognize that most accountants and most lawyers do things as we call a la carte. So I have clients that are very sophisticated. I represent a number of judges. I represent a number of lawyers who are not in my firm. For those people, they send me a contract, say review it. We both know by now I'm supposed to review just the minor points, that they understand all the major points. Other people I deal with are, they'll run a t-shirt shop at the ocean front. They need much more hand-holding. But that's something you need to make clear with your lawyer and with your accountant as you start, because generally speaking, you're paying by the hour. And so if you want to go through it, and the best thing you could do when you're working with me with a contract is say, hey, here's a contract. Could you review this clause, and this clause? I understood the rest of it, but these are things I need to know. And that's something you need to have a frank discussion with the lawyer. Understand that, as one of my partners says, we pay for our time. So if you call and ask us questions, we have to charge for that, because that's what we do. So, you're free to ask questions, but try to work your way through of, let me review it first. Generally speaking, if a client says to me, review a lease, I'm not going to say to them, do you understand it says rent is this many dollars a month? Because that's pretty obvious. It says it right there in black and white. I will point out, oh, by the way, did you see that there's a CAM that goes on top, and here's how that's formulated, which is a common area maintenance charge, and you could run into a problem if this or this happened. But those are things that you definitely want to deal with when you're dealing with lawyers or accountants. Figuring out exactly what help you need, get the help you need. To the extent you can get help from a source that's free like VBOC, I would definitely do that first. I want to talk to other people and then go to the lawyer. And I actually have more and more clients now that say, look, I've researched on this internet. I know the internet's not always true, but let me know, here's kind of where I'm coming from. What do you think about that? And I'll say, well, no, you're definitely on the money there. Or no, that was at one time true. It's not true anymore. Or no, that was never true. Here's what the rules are. Any questions about any of that? I'm going to go over this real briefly. Basically speaking, your company name, whatever it is that you use, you will eventually own what's called a trademark in that. And there's two types of trademarks, common law and registered. A common law is what you're typically going to earn, and that is to say, you don't go ahead and register it with anything, but you use it enough that people get to know who you are. So again, Ashley's sign painting may be her name, or maybe she calls it Signs by Ashley. If she uses that enough, she will have a right to use that name. And if she comes up with some other things like hand-painted signs and nobody else is using that phrase locally, then she can prevent other people from using that. If the business got really big and she wanted to go nationwide, then she'd have to try to register it and register that as a trademark, as the name by which people would know that she does her business. And as we talked about earlier, her business name could be something different. Her business name could be Ashley Signs, but she might have her trademark as being hand-painted signs. Copyrights, when you prepare things like brochures and advertisements and web stuff, all that is basically going to be protected by a copyright, and that's an automatic protection. You don't do any registration of it. Once you create it, you protect it. The thing you need to be careful about is, hey, I saw somebody has a really nice website. I want to use some of their forms and I want to use some of their words. Well, that you just can't do that. Now, if you can use their ideas, but you can't use their exact words. So you can copy a little bit, but you don't, it's almost like in school, you don't want to plagiarize something from somebody else. So just be aware of that. And likewise, if you see a photo on the internet and you say, well, I want to use that on my webpage, generally speaking, someone has a right to that photo. And unless it's in what's called the public domain, if you use it on your website, be sure that eventually someone's going to track you down, because there are people that do this and say, by the way, you violated my copyright, you owe me $1,000. And I get that call usually a couple times a year. And there's really nothing you can do about it other than trying to bargain with them, because you have, in fact, infringed on their copyrights. Any questions?
We're good on our end.
Okay, I'm going to call it, stick a fork in it. Hey, thanks,
All right.
folks.
So
Sorry.
thanks again, everybody, for joining us. Really appreciate it. Really appreciate you, Barry, taking your time and volunteering your time.